Hi everyone, this is a video series on how to expunge dismiss charges. This series is going to talk about what expunction is, what it means for a criminal record you may have, what a dismiss charge is, and how one would go about getting that off your criminal record step by step. This is going to be a 5-part series. The first part is going to talk about what the expunction is, how you identify the kinds of charge, what a dismissed charge might be, and just some other terms you should know as you're starting to dig into criminal records that you or someone you may have. The second part is going to talk about how to find those criminal records, identify them, and basically pull those records through the court's portal system. The third part is going to go through the steps of actually filling out the petition, which is kind of the form that you're going to need to file with the court. The fourth part is going to talk about what do you do with that petition, how to file it, and how to follow up on it with the court. And then the fifth part is going to talk about what to do once your expunction is granted. So I'm going to go through some of these slides on what expunction relief is. So why should you spend your time getting an expunction? The biggest reason is to remove barriers for yourself to employment, housing, or other benefits. Now, to be clear, the type of criminal record we're talking about here is a dismissed charge, which doesn't indicate that you were guilty of anything, right? It's often that the court didn't have enough evidence or for some reason you were found not guilty. It doesn't say you were guilty of anything, but for a lot of reasons, folks may view that negatively, or you may perceive that folks are going to see it that way. And so in North Carolina, we have a specific way to expunge these kinds of charges. So the best way to avoid all this is to expunge them, which means most folks will not be able to see this record. It won't come up in a lot of background checks. It allows you to remove them from the court records or police records, which should help you, in employment background checks, tenant screening applications, credit checks. So this information doesn't surface. There's no guarantees that they may not have it on there, but it will eliminate the official record itself if you are able to expunge your record. So let's talk about some definitions. What are all these words we're using? So expungement or expunction. These words are used interchangeably, but what it means is it is to remove the record itself, remove the information itself from the court record. We're usually talking about criminal charges or criminal convictions. An expunction takes that information out of the court record. So if somebody looks up a particular charge on a particular date and it's been expunged, that information is not there. It shouldn't be held against you. So what am I talking about when I say charges versus convictions? So a charge means you were accused of a crime. Your local DA filed charges against you, but it doesn't necessarily mean that you ended up getting convicted. A conviction is when a judge or a jury finds you guilty of a crime or you plead guilty. We are talking about, in this case, a smaller set of charges. So we are talking about what's called a dismissal or a dismiss charge. So that's when often usually the district attorney chooses not to prosecute or pursue a criminal case. They are going to dismiss the charge. They're saying we don't have enough evidence, or whatever reason they have. They did not take you to trial. A jury did not find you guilty. The other type of result we're going to talk about is what's called not guilty or not responsible. This is when there was a trial, whether in front of a judge or a jury, and they said, no, we don't think this person is guilty of this crime, or they're not responsible. So that is another circumstance that's going to fall into this bucket. So these are the types of expunctions in the videos we're going to talk about. If your charges were dismissed or you were found not guilty, you were not convicted of a crime. Disposition. This is a word that you may hear us throw around. All that means is, where is this case? What's the status of it? Where is it been completed? Disposed means that the judge has ruled or the DA has dismissed. There's nothing more going on. If the case is still pending, there may be a live case. There may be a trial next week. So this word is going to be important. We're going to throw the word disposition around, but it just means, where is this case? Is it completed or is it still going through the court system? Another term I wanted us to distinguish between is district and superior courts. These are the two courts that are going to be particularly relevant in the state of North Carolina. Most of our misdemeanors are handled in district court, and most felonies are handled in superior court, and that includes charges as well. So even if you weren't convicted of a crime, your charge may have been filed in district or superior court, and that is going to determine what kind of petition you're going to fill out. There's a distinction that will come later, but just keep in mind that you may have charges that exist in district court or superior court. The clerk of court, or the clerk, we use that a lot. These are the folks at the front office. The clerk of court is an office, and there are clerks who work in that office. They help you process your court filing. So you're going to go to them to give them your petition or your filing to ask for an expunction. They are going to be the ones handling any follow-up paperwork that you may need or other information. They usually work in the front of your local courthouse or somewhere pretty easily accessible once you walk in. And then the last thing I want to talk about is file number. Every legal issue in North Carolina, a civil case, a criminal charge, they all get assigned this case number. It looks something like this: 25. So the first two digits, the 25, is the year it was filed. So that this particular case number is in 2025. And then there will be a CRS, that which will tell you whether it's in district or superior court, and then there will be a string of numbers after that that just identify the case. But this file number is going to be usually on the top of every piece of paper associated with that case, and you'll need that number as you fill out a petition. So let's, just to be really explicit, who qualifies for the type of relief that we are talking about in this presentation? Anyone who was charged with a crime that was later dismissed, so that just like we were talking about in the last slide, the DA says, I don't have enough evidence, or I don't think this is the person, or I don't want to prosecute, I am going to dismiss the charges against you. If you have a charge that says dismissed, voluntary dismissal, there's a variety of labels for it, but that says dismissed, you can apply for the kind of relief we're talking about today. The other type of person who can qualify is anyone who was charged with the crime and was found not guilty or not responsible. So this probably means that you were charged with a crime, you had a trial, and a judge or a jury said you didn't do it, or you weren't responsible. And in those cases, you'll probably have a much lengthier court record, but because you were found not guilty, you were not convicted, you are able to use this kind of the relief we're talking about, this expunction of a dismissed charge under North Carolina 15A 146. For those folks who are convicted of a crime, there's a lot of, for folks who are convicted, there's a lot of other statutes that may apply. And so you may still qualify for an expunction even if you were convicted of a crime, but we're just not talking about it in this particular video. Here's the kind of folks who you may qualify for an expunction, but you can't use the steps we are talking about today. And I would strongly recommend you consult an attorney if you want to pursue any of these. So these are folks who were charged with a crime as an adult and convicted. You may qualify for relief, but I would seek a lawyer, seek legal advice before you do so. Anyone who is charged with the crime as a juvenile and convicted, there's another statute that talks about the kind of expunction relief that those folks can get. But again, I would speak with the lawyer. And finally, anyone who's been charged with the crime that has, quote, not reached final disposition, which means it's just not done. If you have a trial next week, you cannot get this expunged. If there is anything still pending in your court case, it will say your case has not reached final disposition and you will not be able to get relief yet. This case may end up getting dismissed, or this case you may end up being found not guilty. And so you may be eligible for this kind of relief that we're talking about later, but you can't apply for it while your court case is ongoing. It needs to be finished. And with that, we're going to move to the next section. So please click to the next video where we'll talk about how to actually figure out what criminal records you have, what they look like, and whether they are eligible.